Afternoon, everyone. It's good to be back. I'm glad the session's over. Takes a little while to recover, but eventually we do. So this afternoon, we're going to do the 2022 legislative update. My plan for the day is to start with the big picture, do a reminder on the Rule 12-102 amendment, talk about 2 notary bills, then we'll go to 7 real property article bills, 1 bill on corporations, associations, and 1 bill in the courts and judicial proceedings article. There's 3 miscellaneous bills, and then if we have time, I will mention a couple of the bills that died. Most legislation typically just goes away for a year and comes back again. So we're likely to see these bills in the next session. Before I get started, I want to put a little plug in for the legislative committee of the real property section. We've had a core group of members for many years. We try to guard the law related to real property. We do this by, from time to time, proposing laws, offering technical advice and drafting to propose laws, and opposing those that are ill-conceived and supporting those that make sense. This year we tracked, give or take, 125 bills and commented on, supported or opposed 25 or so. If you're interested in joining the committee, please send me an email. We're always looking for new members who are willing to roll up their sleeves and try to preserve our laws related to real property. For some of you younger members out there, I would encourage you to join. It can be a lot of work at times, but we can really make a difference. And we've been very successful in the past, and I'd like to keep that going with the next generation. So the big picture. So the tallies here don't include the almost 600 legislative bond initiatives. But in the Senate, we had 1,011 bills. In the House, we had 1,487. Of those, 491 were passed. So that's about 20%. Last year, we had about a 35% pass rate. And in 2020, it was about 23%. So it fluctuates from year to year. And no bill that gets introduced goes through a linear process. It bounces all over the place. People come out of the woodwork to oppose them. So it's difficult to get a bill passed. Governor vetoed 10, but probably like the last several years, they'll all get overridden if they haven't already done so. Last year, he vetoed 6 bills. Those got overridden. And in 2020, he vetoed 38, and all 38 got overridden. So basically, all he does is slow down the process. Now, for all the bills that we're going to discuss, They'll all be effective October 1, 2022, unless otherwise noted. So Rule 12-102 amendment. For years, the Maryland Land Title Association has been trying to get the courts to open up the pleadings that were electronically filed. They've been doing that for several years now. And that was because the mere filing of a complaint in the circuit court that affected or claimed an interest in real property was itself a lis pendens. So every time a complaint was filed, you needed to go and figure out, does this affect title? Or is this just a suit about money? But the lawyers, they didn't like it. They didn't want their pleadings to be able to be searched and obtained online. So that meant that we had to go down to the courthouse every time and pull a copy. Well, eventually the court said, you know, you make a good point. We don't want to open up the court files to the general public online, but let's amend the rule. So now, effective April 1, 2022, if you file an action that affects title to real property, you also need to record a notice of lis pendens in the land records to alert those searching the title, or if somebody's going to sell or finance real property, they'll pick it up. Otherwise, your complaint is not going to give notice. Now, this is not prospective, so it only affects actions that were filed on or after April 1, 2022. So if it was filed before then, we'll still need to get a copy. But eventually, this will make things easier for title searchers. So in your reports, I forgot to mention this, in your reports, there are links to the state's website where the bills can be found. So if you just click on it, it'll take you to it. You'll get this. So when I clicked on it, it pulled up the bill. And it has everything in there if you want to get a copy of the fiscal note. And here's the bill itself. Leave that. So the first two bills we're going to talk about involved notary laws. This one removes the prohibition on using remote notarization in connection with a will and a trust. Those provisions were inserted at the request of the Estates and Trust section back in 2019 when we got RELONA passed, the Revised Uniform Law and Notarial Acts that authorize remote online notarization. We tried to explain to them that this was not a wills and a trust. I mean, at the time, wills didn't even require notarization. They still don't, and neither did a trust. But they insisted they had to have it, so we put it in. Now, last year they tried to get it removed, but they ran out of time. And so this year they actually put it in two bills to remove it, just in case one of them didn't get passed and the other one did. This bill also allows for what we call paper remote online notarization. And that's when the principal has the tangible record, AKA paper, in front of them during the remote online session, and they sign that piece of paper in front of the notary. Now, this only works if if the notary knows the principal. I mean, you could do it if you don't know them, but you still have to go through the identity proofing process if the notary doesn't know the principal. So it doesn't really make sense to do this paper run, because otherwise you might as well just do the electronic run. Because if you have to go through that process, that means you have to have a third party vendor, and it kind of defeats the purpose. So, and this was really designed to help the estates and trusts attorneys who are not, who may not be technologically savvy, didn't want to have all the technological requirements to do RON. And so this allows them to do a paper RON. The last thing this bill does is it allows the Secretary of State to increase the allowable fees for a traditional notary. That would be up to $25, or a remote online notary up to $50. I suspect if I had to guess, based on what other states allow for these things, I'm thinking maybe $10 for a traditional and maybe $25 for a RON. The problem that we have right now is that nobody can do a RON for $4. And so it makes people who want to do a RON outside of a real estate transaction, they have to use a notary from out of state. And the computer knows no jurisdictional boundaries, so it didn't really make sense. Doesn't make sense to have a Maryland citizen using Indiana notary because they can do it economically. Oh, by the way, this one's June. This takes effect June 1. Now, this bill was an emergency bill. It became effective when the governor signed it on April 21. And this also contains the deletion of the provisions that prohibited a RON in an execution of a trust or a will. But this also authorizes a remotely executed will. You got to jump through a bunch of hoops, but at least they can now do it. HB 40. This one is basically requires the board of directors to disclose agreements that they make to the members, the unit owners. Boards of directors are allowed to go into executive sessions to discuss litigation, contracts, and personal matters, other things. But this requires them to disclose the terms of any agreement that they come to. It also requires, in connection with the initial sale of a unit, in the contract, whether the Council of Unit Owners has entered into any agreement that settles or releases the Council of Unit Owners claims related to common element warranties provided by the developer. And then, of course, it requires the board of directors to disclose within 21 days any agreement that they make for the purpose of settling a dispute involving common element warranties. And there are similar requirements that are put on the seller on the resale of a unit. Irredeemable ground rents are back in the news. So this, you may recall, about 10 years ago, the legislature passed a bunch of laws related to ground rents and irredeemable ground rents. One of them was the automatic extinguishment if you didn't register your ground rent by a certain time. The Court of Appeals threw that out. But this provision requiring that irredeemable ground rent holders file a notice of irredeemability was never challenged. And so it's coming up on the end of that 10 years. And now this legislation requires SDAT to maintain a registry of all ground rents. And it requires the holder of an irredeemable ground rent to notify SDAT by April 1, 2023, that it intends to keep the ground rent irredeemable. And then they also have to record a notice of irredeemability sometime within 6 months of the expiration of the last notice. And this will continue in perpetuity. HB 107. This law already applied in Montgomery County and Prince George's County. They've just expanded it to every other place, and it requires homeowners associations and cooperative housing corporations and condominiums to update their reserve studies every 5 years. There's also provisions that require them to make sure that a certain portion of the reserve study is actually funded. HB 174. So this establishes that information regarding the status of a rental property as an affected property under certain lead-based paint abatement laws may be an issue of fact at trial. So if you're interested in this, I suggest you go check it out. There were so many changes to this bill, it's hard to make sense of it. I'm taking the legislative service at their word that this is what it requires, because I couldn't figure it out. This takes effect October 1, 2023. Okay, another condo and HOA bill, HB 615. This bill changes the dispute settlement mechanism under the Maryland Condominium Act and establishes a similar dispute settlement mechanism under the Maryland Homeowners Association Act. The dispute settlement mechanism established under the Homeowners Association Act does not apply to the Columbia Association or the village community associations for the villages of Columbia in Howard County. The bill also makes other technical and clarifying changes. The bill applies prospectively and it may not have an effect on any complaints or demands arising under the rules of the condominium or homeowners association before October 1, 2022, unless the declaration or bylaws of the condominium or HOA state otherwise. This bill, HB 77, it was cross-filed as HB or SB 92, has been passed. It's the uniform law. It has been passed in probably 20 or more states at this point. It was the uniform law is called the Uniform Partition of Heirs Property, and it came about because in the past there have been lots of real property that gets passed down from generation to generation, where the number of people who have an interest in it grows exponentially with each generation. And for whatever reason, the property was never administered in a probate proceeding, so the number of people just gets unwieldy, and then developers have swooped in and divided and conquered and been able to get the property for significantly less than it was worth, and wipe out people who may have had an interest in it. And it mostly affected the African American population. And so the Uniform Law Commission came up with this uniform law, and so it was introduced this year. Senator Augustine and Delegate Rosenberg were the champions that brought it to our attention. The problem with the bill as drafted by the Uniform Law Commission is it was designed to be a plug-in for to deal solely with heirs property. It assumed that you already had a statutory process for partitioning real property, and you didn't want it to have to apply to all real property. But it doesn't take into account jurisdictions like Maryland, who did not have, and don't have until October 1, a statutory scheme for the partition of real property. And the process of determining whether it was heirs property is somewhat complicated and does put a burden on the court on how to get that done. So what we did was we took out all those provisions and we made it applicable to all partition actions. And the drafter of the uniform law was he was okay with that because it still got the job done. I liken this to when we were able to get our quiet title process bill passed back in 2016. We had a law that allowed for an action to quiet title, but didn't tell anyone how to do it. And the courts were all over the place. Litigants were all over the place. And so we codified it. And that's really what we've done here. And so it's a good bill. It should help to essentially process the partition actions. We've incorporated the provisions from the quiet title bill to for service of process on unknown people, naming unknown people, posting on the property, and things like that. Okay, next bill, SB 6, landlord tenants rights. This is a huge piece of legislation. This is something that interests you. I would suggest you, if you're involved in landlord-tenant matters, you should definitely read it. It takes effect June 1. The act requires a landlord that uses a ratio utility billing system to provide specified information to a tenant in writing, and establishes that a lease provision that requires a tenant to pay utility charges under a ratio billing system, it's unenforceable if the information is not provided to the tenant. A ratio billing system is defined as an allocation of one or more of the landlord's utility charges collected via a master meter among the tenants by any method that does not measure actual per tenant usage of the utility. The Act also alters the existing requirement that a landlord provide a statement of costs if the landlord withholds the return of a security deposit by requiring a landlord to provide the tenant with an itemized statement of cost incurred along with supporting documentation, which may include estimates of the costs incurred, subject to specified additional requirements. And there are many more changes. I don't want to bore you with them, but it's comprehensive. Okay, moving on to corporations and associations. This bill specifies that operating agreements and partnership agreements may provide for interests in a limited liability company and partnership to be transferred or assigned to other persons, including non-members or non-partners. The bill further specifies that transfers on death pursuant to the terms of an LLC operating agreement or a partnership agreement of a general or limited partnership are effective according to the agreement and are not to be considered testamentary. The bill applies to all LLC operating agreements, general partnership agreements, and limited partnership agreements in effect upon the bill's effective date, which is October 1, 2022. So if you put this in your agreements, it allows the member who acquires it on death to act without opening a probate proceeding. Right now, if a sole member dies and there's nobody else that can operate the LLC or partnership, the PR has to convey the real property. So this should help. HB 1448, Courts and Judicial Proceedings. The district court generally has exclusive original civil jurisdiction over the adjudication of violations of specified local ordinances for which a civil citation is issued or a civil penalty is provided. The circuit courts have concurrent jurisdiction if the amount in controversy exceeds $5,000. In Angel Enterprises Limited Partnership versus Talbot County, the Court of Appeals dismissed a lawsuit and invalidated the penalties that had been imposed on the basis that the adjudication of the civil penalties by a charter county is within the original jurisdiction of the courts and not a local board of appeals established by a charter county under the Express Powers Act, as set forth in the local government article. House Bill 1448 establishes that the district court has concurrent civil jurisdiction with a governing body of a county or the mayor and city council of Baltimore over a proceeding for adjudication of a violation of an ordinance enacted by a charter county for which a civil penalty is provided, the mayor and city council of Baltimore for which a civil penalty is provided, or by a code of a county for which a civil citation is issued under the local government article. So basically this is to deal with a case that where the local jurisdiction did not like the result. Oh, we are cruising. Okay, so now we're going to get into the miscellaneous bills. This one is provides for civil penalties if you stop, stand, or park in a parking spot that's designed for a plug-in vehicle, and the penalty is $100. I point this one out because the penalty is large, and we have these things at my office. There's two of them, and you got to get here pretty early in the morning to get one of those parking spots. Oftentimes I see people who park their car there and get on their skateboard and skate away to some other place. So I understand there's going to be a lot more of these things going in. So if you have one of these electric vehicles, help is on the way. SB 293. This allows title insurers to conduct a annual review remotely. So back in probably as early as, I don't know, 2005, title insurers have been required to conduct an on-site review of every agent they have. And the MIA thought this was the only way to do it. But the pandemic showed the MIA that it can be done remotely. The current commissioner comes out of the private practice, and she had been apparently conducting remote investigations for years. And so when the pandemic hit and nobody wanted to see anybody, the industry cried out for help because they weren't going to be able to get into the offices. Eventually, what the commissioner did was require the insurers to tell the commissioner, if you were to do this thing remotely, how would you do it? So we were all required to come up with a plan that was detailed enough so the commissioner could see what we were doing. And then once you submitted that, if the commissioner was okay with it, they'd say, okay, you guys can do yours remotely. I'm pretty sure every insurer was allowed to do it. And so we did that for a couple of years. And then, of course, all the pandemic-related restrictions got removed, and the industry wanted to continue because it was working well. The commissioner agreed, and so we got this bill passed. Okay, this next one is SB 425. It was cross-filed as HB 568. This authorizes a title insurance producer to essentially pay the commission to a real estate agent on the direction of the real estate broker. This one came about because a couple years ago, this was already occurring where up until this law, and I think it's still probably the law, this is just an exception to it, the commission was earned by the broker. Only brokers were allowed to earn a commission. Real estate agent or salesperson and associate sales or associate brokers, they were working for the broker. And so all the commissions are supposed to go to the broker. Well, brokers, they're always looking for ways to cut costs, and they got out of the deposit, earnest money deposit business, and now they want to get out of the accounting business of accounting for commissions, and that they don't get to keep because they have to pay the salesperson or the associate broker. But in any case, so it was their commission. So the thought was, well, if it's their commission, they can give instructions on who to deliver it to. And so, but it would still be reported as the broker's commission. Well, eventually the real estate commission learned of the practice and issued a ruling that said, no, you can't do that. All commissions have to be paid to the broker. And so the Maryland Association of Realtors went into action and got this bill passed. The settlement agents are not all that thrilled with this because it adds a burden to them to, cut more checks than they otherwise would be required to. Now, this law doesn't require them to follow that instruction that they receive from the broker, but it says they may. My guess is the market pressures will require them to do it. Did I skip one? No, I didn't. Okay, so we've got about 4 bills that died along the way. This first one involves land installment contracts, and it was a pretty hefty rewrite of the existing law. And my guess is it didn't go anywhere because it's a hefty piece of legislation. And anytime you are trying to introduce a bill that makes a lot of changes, it takes the legislature at least a couple years to digest it, because they're always trying to digest new stuff. These folks are not experts in everything, maybe nothing that they see. And so it takes them a while to process it. So my guess is we'll see this bill again next year. This one, there's often cockamamie bills that get introduced. This one, along with two others, I can't remember. I don't remember who was behind it, but one was to allow purchasers of residential property to be anonymous, call themselves buyer one and buyer two, or buyer X. And uh, so that's been introduced twice, last year and this year. This year, actually, there was two of them that tried to do that. But this one was new this year, and you may have read in the news that there are groups out there who are buying residential lots of residential real property, which takes a significant portion, and they pay cash off out of the reach of somebody who wants to buy a home to live in it. And so this delegate had the idea of prohibiting such buyers from making an offer to purchase residential real property for the first 30 days. And then if it were to make it past the 30 days, they could buy the property, but then they would be subject to a 15% transfer tax. And so this didn't go anywhere. I don't know if this will be back, but thought it was interesting. This next bill, called the Anthony Mormon Act. Who was Anthony Mormon? Lots of people wanted to know. Well, he was a real estate broker who introduced legislation, or had had a delegate, may have been even delegate or Senator Hayes, or I don't know who the delegate was for HB 720 on the cross bill. But he introduced a bill back in 2021 that didn't get much traction. Maybe it was filed late, who knows? But he saw a problem with earnest money deposits where the buyer had terminated the contract because of some contingency that wasn't met, or that they had the ability to terminate if they didn't like what the property inspection disclosed, or any number of things, but where the seller wouldn't release the deposit. So the deposit got hung up, wouldn't allow the buyers to move on, or if they wanted to buy another piece of property, they have to come up with another deposit. And so he saw this as a problem. Well, before the bill could be introduced again this year, he died. So that's why they called it the Anthony Mormon Act. Now, apparently, last summer, there was some sort of study group put together to try to come up with a bill that everybody could live with, except for, I don't know, that does seem like they only invited realtors to that session, because didn't hear about this thing until it was actually filed. My guess is this will be back again. We oppose this bill because it's totally unworkable. It had a series of a list of about 15 different events where the buyer could simply claim, that's why I'm getting out, I'm out, it's over, give me my money back. The problem is, it's still you know, if the seller disputes that, what are you going to do? You're a middleman. You're holding an earnest money deposit. You don't get to choose sides. So it really wasn't going to help. Um, they made, the realtors agreed to make some changes, but still it didn't get the job done. Um, it's a bad idea, but it'll probably be back next year. SB 5 or 853 and HB 1270. We've had attempts to get a Transfer on Death Deed Act passed in Maryland for many years, 5 or more. Never been able to get much traction. And that's because we already have these things in the form of a life estate deed and life estate deeds with powers. And so the industry has felt for years that that's enough. But there are folks in the not-for-profit legal services industry that for whatever reason want this, want the ability to allow people to create these transfer on death deeds. And so this year, Delegate Terry Hill put together a study group, invited all the stakeholders, and she actually did a really good job. And she was practical. She listened. She removed all of the offending provisions, just trying to basically get a skeleton bill passed. And so she came pretty close, but eventually ran out of time. And so my guess is this will be back again next year. And so keep an eye out for that. Okay, we've come to the end of the show. That's all I have. If anyone has any questions, I'll see if I can answer them. I don't see, oh, wow. Let's see. I don't think I see any questions in the, only related to the attachment. So I don't see any questions in the chat, and I don't see anyone rushing to have questions, but if you do, feel free to send me an email. Give me a call. And otherwise, you guys get 8 minutes back in your day. And that is it until next year.
Thank you very much, Bill. We really appreciate your time and preparing all the materials for everyone.
You're welcome.